Sri Shashi Tharoor ji.
Not fair intention.
Thank you.
This is too much.
Thank you, Mr. Chairman. I think we are perhaps in the debate overlooking that we have actually combined. The chair has combined both items 19 and 20. So first on item 19, I should mention my strong support for the resolution of disapproval moved by my friend, Mr. N.K. Premachandran, with the support of the Trinamool Congress, who appears to be absent from their somewhat more unusual statement here. You're here. You're here. Well, Mr. Sultan Ahmed has gone along with it.
He's supporting the bill.
That seems to be a slight inconsistency, which I will come to in a minute. But the fact is that on this issue, the worry is that the ordinance clearly amounted to a mala fide and really disgraceful attempt to use the President's legislative powers for the purposes of declaring essentially judgments of the Supreme Court and High Courts as retrospectively ceasing to apply and taking away the jurisdiction of any court to actually adjudicate in the matter. And as Mr. Premachandran pointed out, it's far from clear that the urgency, or I withdraw malified, but it's certainly a matter of deep concern. All right. Let me not waste the limited time available to me, Mr. Chairman, on words. The concern is very important. The urgency that is required to warrant the exercise of emergency powers under Article 123 of our Constitution is simply not demonstrated to be present in this case, and the preconditions for the exercise of powers under this article seems to be lacking, and for this reason I do support the resolution disapproving the ordinance. But coming now to item 20. We have heard a lot of debate already, and I don't want to repeat ground that has already been trodden. But I want to express to you, Mr. Chair, and through you to my very respected friend, the Home Minister, my concern is a concern of principle. I believe that laws in our country should not be made for convenience or to deal with specific cases. A law has widespread application throughout the country, and a law, by definition, has implications that go beyond the specific case the government might intend to deal with. It is an extremely alarming situation in our Parliament today that we are contemplating passing a bill by which some citizens and residents of India are being called an enemy. The ordinance, the bill which of course replaces the ordinance, will, it seems to me, adversely affect the rights of lakhs of Indian citizens, and principally, let us call a spade, of the Muslim community. After all, there are not too many Chinese properties at stake. It is essentially properties of those who went to Pakistan, and that tends to be from only one community. And this is, to my mind, not only borderline unconstitutional, the court should determine that, but also against the basic principles of natural justice. In Bhopal, I have read that 10,000 families have been affected by the ordinance. In other parts of the country, lakhs are affected. In 2013, 2,111 enemy properties were listed. 2014, 12,090. And in 2015, 14,759. So a large number of people are affected by what appears to me to be a rather hastily undertaken action by the government. The worry for me is that this law will explicitly create two kinds of Indian citizens. And this is why my colleagues who have spoken here, including my friend Pinaki Mishra, have suggested that the amendments cannot stand up to the scrutiny of judicial review because they seek to usurp the rights that have been vested in Indian citizens by the 42nd and 44th Amendments to the Constitution, and of course they expropriate properties from Indian citizens. If you look at the judgment of the Supreme Court of 2005, it says very clearly that it affirms the rights of legal heirs who are Indian citizens to acquire the property that belonged to their ancestors, to their families. And now we are trying to deprive Indian citizens of their right to inherit properties and to seek justice through the judicial process. We are removing the recourse of Indians to courts of law. We are usurping, in effect, the powers of the judiciary by saying they can't rule on this. We are bifurcating the very idea of Indian citizenship because we are saying that those who are born in India, live in India, have Indian passports, but are legal heirs of people who have gone to another country, they should suddenly cease to be treated with all the rights of Indians. To my mind, that is a very dangerous and slippery slope for us to tread. Who knows how it might be used in future against others. To deprive legal heirs and Indian citizens from inheriting the properties is to deprive them of their legal and constitutional rights as Indians. And these are, let us face it, minority citizens. There's perhaps an additional sense of vulnerability involved in that. And on top of that, you're going retrospective. This is a government that has denounced the retrospective taxation law, and now it wants to pass a law that retrospectively nullifies all transfers and sales made between 1968 and 2015, even irrespective of the fact they were made in accordance with the laws that prevailed at the time. And on top of that, of course, we should remember, as one of these speakers has already pointed out, the famous biblical injunction not to visit upon the sons the sins of their fathers. Here we are saying that if your father made a mistake, you, an Indian citizen, have no right to disown that mistake. Now, I have looked at a comparison of the ordinance and the Enemy Property Act of 1971 and the Enemy Property Bill that is being brought by this government. And I must say, what is worrying is it's including legal heirs of enemies, even if they're citizens of India or of another country which is not an enemy, but that's academic. That will become an issue, frankly, if China is to be mentioned. I yield to. Yes, go ahead.
I'm telling you, choosing the citizenship of a country, whether it amounts to sin, I don't think. Then again, question is classifying any country. Today, you can classify one country as an enemy country. Tomorrow it may not be. Yesterday it would not have been. How do you classify this? This is a very dangerous situation. I don't think.
Well, let me come to the point Sri Veerappa Moily has just made, because I also want to stress, sir, that in fact international conventions do not provide for any country to be designated an enemy in peacetime, and regulations pertaining to enemy property in all jurisdictions only pertain to property in times of war. So this is already a slippery issue. It has been mentioned by someone that Pakistan disposed of the property held there by Indian citizens. True. But is that the standard by which we should judge India? Do we want ourselves to maintain the highest international standards? Or would it not be ironic for a BJP government to reduce India to the level of Pakistan? I don't think this is a good argument at all. Now, the UPA government has also been mentioned. Yes, we tabled an enemy property amendment bill in 2010. It didn't actually go as far as this bill. It permits Indian-born legal heirs to claim such properties on condition that they establish their status to the satisfaction of the government. Whereas the NDA's bill bars all laws and customs governing succession to property from being applicable to so-called enemy property. And of course, it even removes what our bill had, the duty of the custodian to maintain the enemy or his family in India if they wish to remain in India. Now, in the UPA version, the courts had the power to adjudicate on the question of whether a property is an enemy property or not. Now, what's happened is the BJP, the NDA version says, no, the executive will decide if a property is an enemy property. The judiciary will have no say in the matter. The government, in effect, is promoting arbitrariness and interfering with the function of the judiciary. So my very grave concern about all of this boils down to the legal principle that we are doing some great damage to the legal structure of our country. We are raising serious questions about the value of our citizenship. If somehow there are two categories of Indian citizen and one category does not have the rights of other categories, that is a very dangerous practice. And politically, let us face it, it is also dangerous for our country if that second category that doesn't have the same rights, essentially 99.9% belong to one religious faith. They are basically our Muslim brothers and sisters, and their alienation will be deepened if this bill is passed in the present form. Let us be honest, we have to face the real reality that this is all about. So to conclude, Mr. Chairman, I just want to stress that the provisions of the bill seek to discriminate against some Indian citizens. I believe they will be found by the courts to be ultra-virus, Articles 14 and 21, because they are expropriating and confiscating properties of Indian citizens, and because they are doing so, they will indeed create problems for the government and for India. let us, I beg with the respected Home Minister, let us not, as a government, take unlawful punitive action against a section of our own citizens. Let us not trample on the rights of our own people. Let us now refer this bill to the Standing Committee in order to ensure that it is not, if we pass it today in this form, challenged inevitably in the courts of law. Thank you, Mr. Chairman.